All rise if able.
Right, that was the unscheduled one, which is one a year I'm not told about. Sorry about that. But, I don't know what arrangements anybody has, but we really have to finish this appeal today because Justice Snowden and I are starting another one tomorrow, a 3-day appeal, and we've looked at our diaries. We don't think we can offer you much for a while, so we just have to sit late, I think, and finish this.
Yeah, well,
if you're happy to do that.
Yeah, no, of course.
Obviously, if at some point we get to sort of 5 o'clock and somebody wants a 5-minute break or something, we'll need to that, whether it's a transcriber or anybody else. Okay?
Yes. My Lords, so I was just giving you the introduction as to why we say an order on costs is a decision under Section 68. And if that's right, that should be the end of the matter, save that P&ID has, as you know, prayed in an argument that you have jurisdiction pursuant to Article 6 of the Human Rights Act or Convention on the basis that the judge didn't give developed reasons for his refusal of permission to appeal. Now, that argument, as you've now seen, is advanced in circumstances where the judge at 5 o'clock on a Friday, having dealt with a whole lot of things, refused permission. He wasn't asked for his reasons at that stage. He wasn't asked whether he would give further reasons in the judgment which he had reserved on the substantive issue, nor was he asked to complete Form N460. P&ID never having pursued any of those points, we suggest that the argument has no merit whatsoever. So those are points going to threshold jurisdiction. Now, the substantive appeal, we suggest, is meritless. Now, my learned junior, Mr. Ford, who argued the currency issue below, will deal with it. But without spiking his guns, I just want to make a couple of headline points. Nigeria was billed all of its costs in sterling and paid and continues to pay those costs in sterling. As is entirely conventional, the court held that it should be entitled to recover its costs in the currency in which they were paid. Now, my Lords, bearing in mind the frequency with which foreign litigants appear in our courts, if P&ID were correct, the dearth of both authority and experience in their favour is surprising. As you would expect, a party which has incurred a liability in costs in sterling is entitled to recover such costs in sterling. And if we look at the way the learned judge, Mr. Justice Robin Knowles, put it pithily in his judgment in the court bundle at tab 10, my learned friend took you to, it's page 150, my learned friend took you to paragraph 5, but of course missed out the key last sentence. So the learned judge said, if in the present case, if costs have been incurred in naira, then the court in the exercise of its discretion might have found more that favoured the argument addressed by P&ID. But in the exercise of this court's discretion, the short and neatly expressed proposition from Mr. Ford for Nigeria prevails. Then it sets out what that was. This was a sterling liability paid by Nigeria in sterling, and it should be paid in sterling. And the point at the heart of this is actually a very simple point. What one is, at the conclusion of proceedings, the successful party is getting an award against its liability. be the liability that it has incurred to its solicitors. It is not an award of damages for loss. Of course, it is, you can say it's broadly compensatory in the sense that the party has incurred funds in meeting its liabilities. But what it's actually about is incurring an indemnity against a liability. And once one recognises that, the point simply doesn't get off the ground. And Mr. Justice Knowles' approach, therefore, was correct in principle, and P&ID's novel argument is both contrary to principle and common sense. And as my lords have pointed out, if this were right, I mean, your lordships are aware of how many foreign litigants there are before this court. Every single case practically would give rise to this point where the party being ordered to pay, where the foreign litigant is successful, would say, well, where did you get the money? Most of them won't have Russian oligarchs who are based in Russia, or Ukrainian oligarchs won't have funds in, or unlikely to have funds in sterling. There's nothing actually unusual about this case. This is just another heavy commercial case, but there are, those cases are legion before our courts.
But it's also, it's not, no, I mean, one of the surprising things about that Cathay Pacific case is that, I mean, apparently the point's never been taken before. But, you know, speaking from experience, and I'm sure we've all had that experience, certainly my own experience from sitting in the commercial court, which is now nearly 8 years ago,
yeah,
is seeing summary assessments of costs on a Friday where the costs were incurred in dollars. I mean, it was quite common.
yes.
And I don't remember anybody ever taking these sorts of points.
No.
Either way, if you like.
But, and it's
you,
not,
you knew, as you say, if it was a, you know, if you were dealing with a foreign corporation, as you so often were, and the costs were paid in sterling to the solicitors, you knew that they must have
yes,
have used euros to buy the sterling or dollars to buy the sterling or whatever.
yeah. And the problem is the analogy with a claim, a loss, a damages claim breaks down because that introduces all sorts of other rules about remoteness. How do they apply? And for instance, let's say in order to pay your cost bill, the other side knew you had a business which you had to sell, or an asset that you had to sell in order to meet the costs. And as a result, you lost the opportunity to profit. Are we going to go into that sort of thing? Now, it's not an in terrorem point, as I think Mr. Milner would like to put it. It's simply actually analysing what it is, what is the basis for this. The basis is not a claim for damages and one's assessing the damage that has been suffered. It is simply what was your liability that you were billed in. I mean, so if it was, in most cases, it would be in sterling. If it was a case where the liability was incurred in dollars or euros for some reason, then that might be the right currency. But in our case, this is just a perfectly simple case where Nigeria faced, I mean, you've got to remember, Nigeria, these proceedings were in London because P&ID was seeking to enforce. They came before the commercial court to get liberty to enforce. There was a dispute about where the seat was. We then applied to set aside. Because Nigeria was doing that, it had to employ English solicitors and English counsel and incurred liabilities to them in sterling. It's really as simple as that. Now, turning back to the first point, the permission to appeal, as you all should know, this is ultimately, or not ultimately, this is a point of statutory construction, and in determining what the words in section 68(4) mean, your lordships will look at the purpose of the legislation here, the Arbitration Act. Now, could I take you first to the Sumacan case at tab 15 of the authorities, where this is a decision back in 2015, Court of Appeal. Tab 13, page 166. And at paragraph 15 on page 171, Lord Justice Waller explained in the second sentence, one must bear in mind that there are many sections in which the right to appeal to the Court of Appeal is circumscribed by the necessity to obtain leave from the court at first instance. That was important to those drafting the 96 Act. It's the intention of those drafting the Act to limit appeals to the Court of Appeal to avoid the delay and expense that such appeals can cause. And the wording of the Act, the bill, was altered to make the position absolutely clear. And then he explains over the page that the philosophy is reflected in section 1A, which provides that the object of arbitration is to obtain the fair resolution of disputes by an impartial award tribunal without unnecessary delay or expense. Consistent with this objective, one might expect the decision as to whether parties had excluded the right of appeal to be something finally decided by the court at first instance. Now, the general policy of avoiding unnecessary delay or expense. Now, in our submission, that applies. I mean, if one just stands back and thinks of a case like this, where we had an 8-week trial before the commercial court at the beginning of last year, judgment came in the autumn, and then, as you know, in the beginning of December, we had the hearing. Now, in our submission, part of the philosophy is that that should be the end. Mr. Justice Knowles having refused permission, that should be the end of the story. Mm. We shouldn't have further delay and expense, including dealing with the output of the court. I mean, the idea is that everything should be final. And if we can go to the National Iranian Oil case, the judgment of the court recently, that is at tab 35. And if we could just pick up a couple of points, I know you've seen some of this already. At paragraph 53 on page 705, Lord Justice Mayles makes the point. I mean, we see different expressions used. So here he talks about third and of direct relevance in the present case. There is at least a strong indication that a decision under section 73 was within the compass of section 67 and 60 or section 68, and therefore should be regarded as a decision made under those sections. Now, just stopping there for a moment, what's important to recognise is a decision under section 73 is necessarily a decision under section 73. It's not actually a decision, as it were, if you were taking a very literal, formalistic approach, under section 67 or 68. But what Lord Justice Mayles here is saying, well, it's within the compass. In other words, it's within the matters which are covered, or that get covered under section 67 and 68. Then, if we go to
Can you remind me, where did you get the words within the compass?
We came from Lord Justice Waller's judgment in the Summercamp case.
That's right.
Because this is all citation from the Summercamp case.
I mean,
So if you go over the page to 706, you can see in the quotation from Lord Justice Waller, he uses the words within the compass of the process of deciding.
If you look at Lord Justice Waller in Summercamp, National Iranian Oil, and the Czech Holdings case, what you have is a number of expressions being used. Now, of course, they're not. It's in the statute, or none of the judgments are a statute that one's got to apply them as such. But you've got expressions such as whether something is within the compass, part of the process is another one, entirely ancillary is another one, I think ancillary to or supplementary to. Those are the different expressions that you see being used. And the point that you see in the extract that he, as my Lord the Chancellor points out, that he's quoting from Lord Justice Waller in paragraph 32. If you go over that page, you see in the sentence, the first complete sentence on that page, for that reason, the wording of section 69.2 brings questions that arise on section 70 within the compass of the process of deciding whether permission to appeal should be given, and so on. In the same way as subsections 2, 67 and 68 bring decisions on section 73 and 72 and 3 within the compass of the decision-making process. Now, of course, the argument that can be made against me, and I think my Lord Justice Fraser might have been saying this earlier, or certainly my learned friend was, you can say, well, matters that fall within section 73 can be sort of preliminary questions to the decision that you then have to make under section 68. Because if you fail on section 73, you can get knocked out at that stage before you get into section 68. But what the Court of Appeal here was saying, and had said in the earlier case, what it meant by within the compass, I would suggest, is it's looking at the overall nature of the issue and the process that you're looking at. Now, if you take our case, or any case under section 68, part of the issue that your lordships have to decide is a case that's brought, say, by Nigeria here under section 68. Whichever way it went, the consequence would be, in ordinary course, that costs would follow the event. So the successful party would expect to recover its costs. That's the process of our litigation. So if you bring an application to set aside an award, and that carries with it the consequence that there will be a costs award. If you're successful, you'd expect to get your costs unless you've done something wrong or you've argued issues on which you failed, but you expect if you were successful. Is that what one would describe as being within the compass of the process of deciding section 68? Or is it ancillary to or the other words that are used? And if you go on in National Iranian Oil, or if we pick it up at paragraph 58, paragraph 58 deals with the Manchester City case, and it's quite easy to see in the Manchester City case why that decision went the way it did, in that the question of whether the court would publish a judgment was, I mean, firstly, it obviously didn't have anything to do with the section 67 or 68 process, nor was it the consequence of it in the sense of one party seeking to recover their costs. It was something entirely separate, where one of the parties said, I want to have the right to publish this, and the court then had to decide under its jurisdiction. And so in our submission, that is an entirely different situation, and that's the point paragraphs 39 and 40 that get quoted on page 708. But then paragraph 60 on page 708 deals with
You say, sorry, just saying, I mean, you say it has nothing to do with the section 67 or 68 process. I mean, I don't think you mean that literally. I mean, in a sense, it had everything to do with the section 67 and 68 process because it was the judgment on the application.
Yeah. Your lordship is right.
As to whether to publish it or
Well, I didn't mean it. Obviously, sorry, I misspoke in a way. Of course, it has something to do with the process in the sense that it's a judgment in relation to an application under section 67 and 68. But the issue under consideration was an issue that arose outside of what sections 67 and 68 were concerned with, it was concerned with whether or not the court should allow you to publish the judgment. Yes, it's a judgment that arose under section 67 or 68, whichever it was.
I mean, I'll play devil's advocate for a
Yeah.
moment. I mean, if you institute proceedings in the courts, there's at least a presumption that at the end of the proceedings there will be a judgment which will be, as a matter of open justice, published. And in the same way as it might be said, if you start proceedings, you will at the end of proceedings have a decision by the court on the costs, the incidence of the costs of the proceedings. Why do you say they're so different?
Well, the issue in relation to a judgment I mean, the judgment, the question of whether you should publish the judgment, I mean, it is not, I mean, it's got nothing to do with the substantive decision under section 67 and 68, nor is it anything to do with the outcome of that decision and the consequence of that decision. This was concerned with a separate point, which was, I mean, you've got to remember it's to do a separate point which is concerned with an arbitration award, a judgment, and whether that judgment is then going to be made public.
The subject matter of that judgment is the resolution of the section 67 and 68 challenge, isn't it?
It is. Yeah, I mean, that's right.
To use your own words, not against you, but just to draw the parallel which my Lord Justice Snowden was right to draw. You said if you bring an application to set aside, that carries with it consequences that, and you went on to say, costs follow the event.
Yeah.
One could equally well say if you bring an application to set aside, that carries with it consequences that there'd be a judgment on that application. That's also the court's framework of dealing with section 68 on both.
But then the question of what the court will allow the parties to do with the judgment, I would suggest, unlike the question of costs, which is just something that follows on from the judgment, question that was at issue in Manchester, in the Manchester City case, was entirely separate question. It's not part of the process.
That was the point that I made in paragraph 40, that's quoted at page 708, about the middle there. Whilst such case management decisions may be said to be part of the process of reaching the substantive decision, the question whether the substantive decision should be published is a distinct question separate from the decision itself. And it was the application. I mean, what happened there is that both parties opposed publication of the judgment before the judge. And the judge said, applying Lord Justice Mance's judgment in the City of Moscow case, that the judgment should be published. So that was the application of the common law principles derived from that decision.
Yes,
of Lord Justice Mance in the Court of Appeal.
That's right.
And then there was an appeal to this court, and that was the context in which it arose.
Exactly.
So it was entirely separate. And of course, it was the application in respect of which the merits judgment was given was under section 67 or section 68, whichever it was, I forget which now. But the decision that was under appeal was a decision about publication, which involved the application of the common law, and not the application of any principle of derived from section 67 or 68.
Exactly. And I would respectfully say that when you are looking at a costs order that a judge makes at the conclusion of proceedings, any proceedings, doesn't really matter. I mean, let's take an ordinary trial. The costs, the judgment, you obviously you deliver your judgment on the merits. Then stage 2 is I consider in the light of that how I'm going to deal with costs, and because under our procedures, you know, costs follow the event and so on. Now, I would suggest just however, just in an ordinary case, that process of deciding the costs would be regarded as part of the process of determining the case. If one looks at it just in an ordinary case. Now, so too, when you're making your decision under section 68, the question is it simply, is one concerned with simply the decision that I am going to set aside or I'm not going to set aside, or is it the whole judicial process which includes the orders that I make consequent on that anterior decision to set aside or not? And my submission is it does envelop or encompass, I should have said, the whole process. And that's the issue you have to decide as the one of statutory construction. Now, the reason I say that statutory construction is the right one firstly I say that is, the words are certainly capable of bearing that broad meaning, because you see the policy in these cases is adopting a broad meaning. Secondly, I say that is consistent with avoiding delay and expense, because the parties, the judge having refused permission, that should be the end of it, and the parties shouldn't be involved in more delay and expense. Yes, it's not delay and expense directly of the arbitration dispute, but we're still in the fallout, as it were, from the arbitration dispute. But then the point I also make is the point, perhaps we can pick it up in perhaps pick up a couple of further paragraphs in the judgment. If you go to page 709, after 60, at 61, Lord Justice Knowles makes the point about avoiding unnecessary delay and expense. At 62, he adopts the words, the statements which suggest that a decision which is part of the process is a decision under section 67 or 68.
Wait a minute, you've got to be careful. He says, I mean, just before I put the point to you, I mean, both of the questions, such as do I publish the judgment or do I make an order for costs, could be described as, quotes, consequential matters. So in paragraph 62, what Lord Justice Knowles says is there are statements which suggest that a decision which is part of the process of reaching a final decision on a challenge to an award. Well,
yes.
That is done in the judgment whereby the award is either set aside or one of the other things that is done in set out in section 68, 1 to 3, is done to it. But it's the process of reaching a final decision on the challenge.
Yeah, no, Your Lordship.
Why doesn't costs, it might be said, well, okay, but costs and decision as to whether to publish the judgment is after that.
Well,
there's no difference between the two, I think is the way it's put.
Well, what I'm looking at the moment is the broad approach. That was the submission I was making that the Court of Appeal is taking. I'll come back to your point that there's no difference between publishing a judgment and costs. But at the moment I'm focusing on what is the approach. So Your Lordship is right, 62, where his Lordship used the words part of the process of reaching a final decision on a challenge. That, as I said, you can make the point against me that that's looking at steps along the way.
Yeah, and that's where, for example, we come to section 73.
Yeah. Yes, I mean, I accept, subject to the point that a decision under section 73 is actually a decision under a particular section, but that is a fair point. But you then have in 65, in the middle of the paragraph, where we see him also using the words, adopting the words part of the process, but again, it's subject to the point Your Lordship made to me and within the compass. And then 2 sentences on, decision is a broad term, and the determination of a section 73 issue is naturally to be regarded as a decision under section 67 or 68 as a matter of language, whichever way it goes. So and I rely on it being a broad term. But 66 is important. Moreover, it's in accordance with the policy of the Act to interpret section 67.4 and section 68.4 as encompassing such a decision. That's a decision on section 73. But it would be paradoxical to interpret those provisions to mean that only the first instance court can grant permission on the final decision to uphold or dismiss the challenge to an award, but the Court of Appeal can give permission on preliminary or case management decisions when the first instance court has refused such permission. So just stopping there, that's the point I was making before lunch, the lunch and adjournment, the paradox. What the point he's using it by is by contrasting the position on a final decision and on preliminary or case management decisions. But I would suggest it is entirely right that it would be odd to say that the Court of Appeal can't give permission on a final decision, but it could give permission on preliminary or case management decisions. One has to ask, why is that consistent with the Act? And I would say it isn't consistent with the spirit and...
I entirely see that if you're looking at the process leading to the making of the final decision under section 67 or 68. So you couldn't derail, if you like, or further prolong the section 67, 68 determination by, for example, trying to appeal to the Court of Appeal on questions about whether evidence should be given orally through an interpreter.
Well, that's a classic, isn't it? Because it's a rehearing under section 67, and the court has to decide whether or not, for example, to rehear all the witnesses who've already given evidence before the arbitrators, or whether to accept their evidence in writing or whatever. So imagine that, and the court of first instance making a decision, for example, to hear all the evidence. Sorry, not to hear the evidence, but to deal with it in writing. And there were then an attempt to appeal that to the Court of Appeal. I think we would say, well, hang on a moment, that's clearly part of the process.
But
I'm
entirely agreeing.
I think what's happening at the end of the process is more problematic.
Well, that's the question.
Even after the end of the process.
Well, that's why we're here, because
exactly.
That's one of the reasons.
But I think one has got to take it in stages as well. I think the discussion shows that everybody recognises that an interlocutory decision which the trial judge makes is one that can't be appealed without his leave. And that's the consequence of section 68.4. Yeah. Now, the important thing to remember, though, is a decision that the judge is making at an interlocutory stage won't be a decision actually, in the way my learned friend puts it, under section 68. No. For instance, the type of decision that my lord was putting, or decisions to do with the scope of disclosure, for instance, that would all be a standard case management decision being made under the CPR, but in our submission, the effect of the sense of the Act and this authority is that that isn't something, if the judge didn't give permission to appeal, that the Court of Appeal could interfere. Because really what the Court of Appeal is saying, and the Parliament is saying, is the judge is the master of all of this. Now,
that would suggest that the acid test, if there is one, is not what is the basis for the jurisdiction which is being exercised in quite such a rigid way. You'd say it can't be.
No, what it suggests is that what you're concerned here in Parliament was concerned with a broad policy of two things, and there are two things in the policy. We want to avoid delay and expense. And the avoiding delay and expense comes in a number of ways. The difficulty of bringing arbitration claims before the court. But once you are before the court, it is to try and shut it down, save in those cases, once the judge has decided it, where he has given permission. Now, what you then have to decide, my Lord Justice Snowden has put to me, well, all of these dicta are talking about steps along the way. The question is it consistent with that to then say we're going to treat differently the determination that the judge makes having reached his decision on section 68? In other words, is the cost matter part and parcel of that decision, or do we treat that as being entirely separate although we don't treat the case management decision, we're going to treat his cost decision as falling out with that, and we're going to allow the Court of Appeal to have separate jurisdiction to entertain it. Now, my submission is firstly that that is inconsistent with what we're seeing in these cases and the policy. It also gives rise to a further paradox, which is similar to the paradox that my Lord Justice Knowles was talking about, which is the one I described earlier, where the costs appeal is raising issues which trespass the ground that has been covered in the judgment. For instance, issues about, in this case, whether witnesses were dishonest or whether the party behaved dishonestly. And in my submission, although I think your Lordship reacted against that to say, well, wouldn't you be bound by the fact that the judgment is final? The judgment is only final for this purpose and before the Court of Appeal on the basis that you can't set aside the decision to set aside the award. That if P&ID were right, I would suggest there's no reason why a party in their position cannot mount an appeal on costs, seek permission to appeal, on the basis that there were matters that the judge dealt with in his judgment which weren't fair, which he then reflected in his costs order. And in my submission, that would be entirely inconsistent with the spirit of the legislation to allow, even to contemplate that sort of thing. And I think that's, I would respectfully say that's what you've got to test. My learned friend says, well, my appeal here only concerns this freestanding currency point. This appeal is an appeal that could arise in any piece of litigation, and it doesn't involve us looking at anything in the judgment. We accept everything in the judgment. This is just entirely freestanding. But if your lordships were to allow his argument, you need to recognize that this opens the door to other appeals and a P&ID Mark II, where they might choose to come along and make challenges to matters which are part of the substance of the award, but under the guise of a costs appeal. And in my submission, that would be allowing through the back door, which you can't do through the front door.
And so in terms of statutory construction, I think you would say that it's by necessary implication that section 68 has to be construed in the way that you're urging on us.
Yes.
So that absurd artificial result where the Court of Appeal has jurisdiction on costs, but it doesn't have jurisdiction on the substantive challenge is avoided.
Exactly. And that's what Parliament intended. Parliament intended a broad approach, and that's what you see in these cases. And in my submission, this is the logical extension of the broad approach.
The only thing, I don't see it in the cases because none of the cases deal with costs, and the cost regime is in a separate statute, which is the real issue.
My Lord, sorry, I'm not suggesting, other than the obiter dicta of the Master of the Rolls in discussion with Lord Panic, I'm not suggesting any of the cases have decided this point. I mean,
because the thing about the Section 73 argument that you've explained is that's within the framework or the architecture of the Arbitration Act.
it is, but
The cost regime isn't.
But
that's right.
On the other hand, I suppose it might, if we go back to the case management example we were talking about earlier on, about whether under a Section 67 challenge, the evidence was to be heard all over again or simply taken from the written evidence or a transcript of the evidence before the tribunal. That would be a case management decision by the court, which isn't a case management decision under Section 67 as such. It's really the court exercising its case management powers under the CPR. All of the case management decisions that a court reaches when conducting a Section 67 or 68 case are actually ones under the CPR and not ones that are prescribed by the Arbitration Act as to how the court will manage the process. So in my submission, or one can see that one naturally, it's not an answer, as I'm not saying my Lord is saying it's an answer, but look, my Lord is right to say costs arise under a separate statutory regime. That's right. But the question is, that may be so, but the question is the decision that you make under that separate regime, is that still encompassed by the words, this is a decision ultimately under Section 68(4)? Because
you come back to, and conscious I may be repeating myself, but one comes back to a party who brings a claim under Section 68. His claim here in Nigeria, what were they seeking? They were seeking to set aside the award and to recover their costs of the set-aside application. And in my submission, it becomes somewhat artificial to say that the decision, yes, you have a separate statutory regime that gives the court the power to award costs. But if one asks oneself, yes, accepting that there is that statutory regime, but is this decision, I mean, it's certainly a decision consequent on the Section 68. Is it what you would regard as a decision? Is the cost decision under Section 68? In my submission, within this statutory framework, the answer is yes.
Can I just put one, or ask you to comment on one other point? You mentioned the parliamentary desire to avoid delay and expense on a number of occasions. Can we actually look at what it actually is? If you just turn back in National Iranian Oil to paragraph 21,
yes,
where section 1 of the Arbitration Act is set out.
I mean, if your lordship, it's at page 719 of the bundle.
Okay, I was looking at page. Okay, I was looking at conveniently at page 697 because I had the authority open. But
that's fine. I was just
that's fine.
your lordship wanted to see this section.
So the object of arbitration is, and the provisions of this part are to be construed in accordance with this. The object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. So, I mean, could it not be said that you have obtained the fair resolution of your dispute, which is the subject of the arbitration, without unnecessary delay or expense, once the Section 68 challenge has been resolved?
Well,
but the questions for of the costs of that process, that exercise under Section 68 by the court, are in a sense outside what the Arbitration Act is looking at. Because when you say delay and expense, it's not delay and expense generally that people don't like. So people delay and cause expense in these courts all the time. We don't like it, but it's not what the Arbitration Act is.
But with respect, your lordship's actually looking at this the wrong way around. Looking at Section 1 the wrong way around. Section 1 is setting out the policy of the English law approach to arbitration. So the first policy, what Section 1A is dealing with, that's actually got nothing to do with Section 68. That's the object of arbitration, i.e. it's what we say as a matter of law, is to obtain the fair resolution of disputes by an impartial tribunal without necessary delay or expense. Then B, the parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. In matters governed by this court part, the court should not intervene except...
But I got into this because I was picking you up on your point. You were saying Parliament wouldn't have wanted there to be an appeal on the costs of a Section 68 challenge if the first instance judge didn't give permission, because it's contrary to the policy inherent in the Act of avoiding delay and expense. And I was trying to pick up where do you get the policy of the Arbitration Act is to stop courts hearing appeals against other courts exercising their discretionary powers in relation to the costs of proceedings in court.
My lord, we have to wind back a stage. You have to ask. Section 1 is setting out the general policy. Section 68(4) provides that. Section 68 is dealing with challenging awards. So, for serious irregularity. And there are certain, as your lordship knows, restrictions on your ability to do that. For instance, if there's an irregularity that occurred in the course of the arbitration that you should have known about and so on, that sort of thing, it will be difficult. So then the leave of the court under 68(4) is required for any appeal from a decision of the court under this section. So you have to ask yourself, why why did Parliament say that? What was the purpose? I mean, there's an unusual situation. Why has Parliament put all these restrictions on your ability to challenge awards and to appeal awards on points of law, and then restrictions on your right to appeal? The answer is because Parliament, firstly, is saying, I mean, this is part of the philosophy of the Arbitration Act, that arbitration agreements should be respected. So if parties agree to resolve their disputes in arbitration, we honour that. The second thing is the court will intervene as little as possible, and the third point is that, as I would suggest, which is consistent with all of this, and this is what you see in the cases, part of this is also the policy of resolving not simply within the arbitration tribunal, but resolving everything expeditiously and without delay and expense. And that includes the court proceedings, but it's reaching finality, which is very important.
Well, I think the point is it's the dispute, it's no unnecessary delay or expense in the resolution of the dispute which the parties have agreed to refer to arbitration.
Yes, once you get out of the arbitration itself and you're into the court proceedings, you don't, as it were, abandon the desire to avoid delay and expense. That permeates everything, including the restrictions on the right to appeal.
Because Section 67 and 68 are aimed at undoing the arbitral process. And therefore, in a sense, I can see why, as it were, everything leading up to a final decision on a Section 67 and 68 challenge, because of the impact it could potentially have on
They're
an
not just
arbitral decision.
Sorry, I'm sorry, I didn't mean to interrupt you. I apologise.
No.
They are, of course, the applicant who makes his Section 67 or 68 challenge is trying to undo things, but of course he may fail. So this Parliament has adopted an even-handed for both parties. So assume, for instance, we had failed in our Section 68 application, and we were the ones who had some costs issue. You have to look at it in that situation too. And in my submission, the whole idea is that you get to finality, that you're not going to be involved once the trial judge has looked at it and given his decision one way or the other. It doesn't go any further. It's that finality. And the reason you want finality is because that's part of the whole concept of arbitration, which is the parties had a consensual.
Sorry, the point I'm trying to make is I understand your desire for finality, but is it not finality as to the status of the arbitral award itself, which is what the Arbitration Act is dealing with, not finality in relation to, for example, whether the court puts the record of its decision on the internet, on the notice board, or otherwise, or anything else to do with the court process, consequential upon the termination of the court process?
Well, my lord, we come back to the point, what does one mean by the court process? And I would submit, the question of whether you're going to put the judgment on the internet or whatever it is, that's something separate and not part of the process of either making your decision or the consequence between the parties of the decision. Whereas costs is, I would suggest, form part of the decision-making process which is before the court. In my submission, that can't be separated out from other decisions that you make as part of the process. So, I think really your lordships have my submissions on the Section 68(4) point, and I think unless there's anything else I can assist you with, I'll move on to the Article 6 point. Now, our submission on this is a relatively simple submission. This isn't a situation, you've got to remember, where we're not in a situation where a judge has delivered a judgment which, on the merits, and there's some deficiency in the judgment, and a party is saying, well, it's all very unfair, I can't understand his decision-making process. I mean, your lordships obviously are all sat at first instance at the conclusion of a trial when presented with a whole lot of issues. And so we had this day, this Friday, where we had the main issue for the judge was whether or not P&ID should be given permission to appeal. I mean, if you go to the transcript, just so one can see, it's in the court bundle at tab 9. And what actually happened, if you go to page 86, it's tab 9, page 86. So we all turn up at 10:30 on Friday, the 8th of December. And what happens is Mr. Andrew turns up with unheralded, with counsel trying to, hasn't put in a skeleton argument, and he's come to make an oral application on his own behalf for permission to appeal. Not surprisingly, he got rather short shrift. So that's what we dealt with in the first couple of pages.
I mean, just to be clear, I mean, I was surprised by this until relatively recently, but you know, there is a line of case law, which does say that people who are subject to criticism in judgments can, on occasions, appeal.
There is a line of cases, but it's a bit unusual.
Oh yeah, it's
no.
more usual in the family division.
Yeah, but it's also a bit unusual where you are a director of the P&ID, you were instructing the counsel team who were bringing the case, and part of your complaint is, whoa, I didn't realise, notwithstanding the fact I cross-examined him to say that he was a lying cheat, that you're surprised that the judge might say that in his judgment. This was more than a little unusual. But I agree, there is a line of authority, and Mr. Borre tried
Mr. Borre tried to, well, sorry, Mr. Gray tried
Mr. Gray in the Borre case, yeah.
Yeah.
No, I wasn't saying there's no such line. But anyway, I'm just telling you what happened that day.
Yes.
And Mr. Andrew, I think, in the actual substantive judgment, was he entitled potentially to a success fee or life-saving 3 billion, life-changing, I think.
There was my expression was the life-changing 3 billion.
3 billion.
3 billion. I mean, what's 3 billion between francs?
3 billion.
3 billion. It's nice work if you can get it. Trevor Burke, KC, or Sterling.
Right.
So Trevor Burke, KC, stood to get 800 million.
850, I think.
Yeah, I think it was 800. Anyway, it's pretty nice work.
But I've distracted you. I'm
Yeah,
sorry.
no, I mean, there is actually, I mean, you know, there was an important point in all of this. I mean, it is extraordinary conduct was going on in this case. I mean, it's now all seems amusing, but you know, Nigeria was facing a judgment or award for an $11 billion, which even to Nigeria is an incredible sum of money. I mean, it's a sad story. But anyway, what you then had was...
I think for the transcript, you'll probably be misreading the raised eyebrows as being raised in amusement.
No, I wasn't. But I mean,
Certainly at this end of the bench.
It really is a case, actually.
I don't think any of us are amused.
No. I mean, my lords, I wasn't intending to. What I'm just saying is actually a case of sort of actually shock and horror that this was going on. Anyway, that probably the less
so
we say.
the point of looking at this is to say that at the outset, Mr. Andrew.
Yeah. But
made his, and that occupied how long?
That just it goes through for a couple of pages, and then at page 88, we get to the submissions, and what happened I mean, there's no point turning the pages, but it was a long day where his lordship was presented with a lot of issues. And when we get to page 135, which you've already looked at, and of pages 199 to 200 of the mini-script, it's at the end of the day, as my Lord Justice Fraser pointed out, I had to go at line 15 on 199, and then Mr. Milner makes what he described as a very short application. Now, but what one's got to see, before one considers that, if you've seen the judgment already at page 150, what was clear was that what Mr. Justice Knowles had already decided, that he thought Mr. Milner's argument was wrong, that there's a distinction between the indemnity in respect of a liability for costs and a claim for damages. So at page 135, Mr. Milner says at line 19 to 20, there's a real question of principle here. And he then said, your lordship held the principle does not in fact exist. It's therefore clearly a question of law. The White Book currently treats that as being correct, and your lordship has disagreed with that. It's a clear and discrete point of law that plainly merits consideration by the Court of Appeal. And I ask for, respectfully submit, ask for permission to appeal. Now, what actually, if you think about it, in relation to that short submission, you know that the judge obviously has disagreed with you on the substance. What is it you're expecting him to say at 5 o'clock on a Friday afternoon? I mean, what he's going to, and what is he saying? Mr. Milner has said it's a point that merits consideration by the Court of Appeal, and what he's saying is, I'm refusing you permission. That's shorthand for saying, I don't think the point is sufficiently arguable to have realistic prospects of success for the Court of Appeal. Now, if he'd actually said that, would Mr. Milner be making his argument at all? And what's interesting, look at what Mr. Milner's response was when the judge said, I'm going to decide now to refuse the permission, so you have that outcome. He just says, I'm obliged. Then he says, I anticipate being instructed to seek permission on that point from the Court of Appeal and ask for a stay. So he's saying, I'm going to go to the Court of Appeal. And Mr. Justice Robin Knowles then refuses the stay application and thanks him for putting it concisely. So everybody's putting everything concisely. And that's the end of it. And Lord Hoffmann, over the page, says, thank you very much for sitting late. Now, one would have thought, I mean, we've got incredibly competent counsel, Lord Hoffmann and Mr. Milner. If they wanted something, if the judge to say something more, they would have said there and then, thank you, but could you tell us a bit more, provide a bit more by way of reasoning.
Or they would have written to him afterwards and said, on reflection, although we had to sit late till 5 o'clock on Friday, we don't actually think we dealt with this point adequately. Could you please give further and better reasons? Well, they knew he was giving a judgment the following week on the substantive question of whether they should have permission to appeal the main judgment. Yes. And exactly. I mean, I would respectfully suggest, I mean, I have the greatest respect for Lord Hoffmann and Mr. Milner, but just basic courtesy to the judge, you would have said, we're thinking of going to the Court of Appeal. We need, on this point, we'd like further reasons. And it's not as was said by looking at one of the cases, the judge would be going back sometime after the event to make up something new. I mean, he's plainly thought it, heard the argument, doesn't think they're right, and would have put forward something shortly if they'd asked. So they could have asked him orally then. They could have, I mean, maybe 5 o'clock they'd all had enough. On Friday they want to go home. Can't criticise them for that. Alternatively, they could have said, you're delivering a judgment next week, can you please set out more reasons? Or they could have written to him, or they could have asked him to fill out the form. Now, against that background, the suggestion that this is an interference with their human rights, which is what's being said, and that they've not had fair process, in my submission, the court should give that extremely short shrift. And the points being dealt with
in the course of extempore judgments where you're dealing with a whole host of things, I would suggest this is, there's nothing to criticise Mr. Justice Robin Knowles in dealing with it in that way. And if one of the parties had wanted something more, they simply had to ask him. So in my submission, the attempt to skirt round the jurisdiction point by putting forward an Article 6 point is hopeless. And even if your lordships thought there was something in it, the answer to it would be that, as is now accepted, the matter would have to be remitted to Mr. Justice Robin Knowles. And of course, in that situation, I would suggest it would actually be wrong for the court, for this court, if you were with me on jurisdiction, but against me on this point, it would be wrong to go on and deal with the merits of the appeal, because that is then, as it were, predetermining what Mr. Justice Robin Knowles would do. And I think my Lord said, well, can't we direct him as to what he should do? In my submission, that would be entirely wrong, because that would just be usurping.
Well, I was being rather flippant.
Yeah, I mean, I'm saying it with the greatest respect, but that in my submission wouldn't be the right way to go. So my submission...
But your fundamental point is that this just isn't an Article 6 point at all.
It's not, and your lordship should be wary of encouraging this sort of point, because it's really, I would suggest, it's...
Can I put a slightly different point? I understand you say you shouldn't be encouraging people to take Article 6 points, but can we just leave Article 6 aside for one moment? The premise of this argument is that there is no jurisdiction in the Court of Appeal.
Yes.
And therefore, the determination by the trial judge of the application for permission to appeal, in effect, puts an end to the case.
Yes.
As a matter of law here, in this jurisdiction, in a situation where there is no further right of appeal and your case ends with that decision, the modern approach, certainly as exemplified by the Fundau Dam decision, the Court of Appeal decision, is that the decider should explain, albeit briefly, why. I mean, do you differ from that?
No, the decider should, albeit briefly, as you say, decide why. But you have to, if you look at, I mean, firstly, in the context of an interlocutory, or these aren't interlocutory, these are final decision, but in the context of a Friday where you're dealing with a whole series of things, actually the parties understood what Mr. Justice Knowles was saying. And if they hadn't, they should have asked for more reasons. So that one can't simply start it by saying, well, all he said was, I'm refusing you permission to appeal. It's in the context where experienced practitioners, you know what his decision was on the point. And what he's saying is, I refuse. What he's communicating to you is, I don't think your argument has sufficiently realistic prospects of success to trouble the Court of Appeal. And I mean, what else was he going to say? He would have said, I've told you in my judgment already why I think you're wrong. I don't think this is sufficiently arguable that we should be troubling the Court of Appeal. It doesn't have realistic prospects of success. So he didn't say that, but everybody understood that's what he was saying.
Yeah, I think my point to you was a slightly different one, which is, if there is another body above you that can give permission, even if you don't, it may be appropriate to say comparatively little in refusing permission to appeal, because it's not the last word.
No.
But certainly my reading of the current trend of authorities is that where it is the last word and there is nobody else you can go to for permission, that body making that decision has an obligation to explain itself a little bit more fully.
I'm not in any way disagreeing, but I do come back to, in the context of the decision that Mr. Justice Robin Knowles was reaching.
Yeah, you say in context, though, you know, given the circumstances, given the context, given the opportunity to ask him to do precisely that, this isn't an infringement of anybody's
Exactly.
right to a fair process, Article 6
Yeah.
rights.
And what you're faced, what one, I mean, I think, just thinking aloud really, you've got an earlier ruling that he'd made actually at, I think, 2:45 or 1442,
Yeah.
basically saying, basically rejecting Mr. Milner's argument that this case was, that he should apply the same principle as Mr. Kimball in Cathay Pacific. The judge saying, albeit in a very short ruling, I don't agree that this case is on all fours with Cathay Pacific. This is a case where the liability was incurred in sterling, paid in sterling, and therefore you're entitled to be indemnified in sterling. And that, what's happening at the end of the day is Mr. Milner saying, please may I have permission to appeal on the basis that was wrong, really because of Cathay Pacific, because that was what the reference to the White Book was. And the judge really saying, shorthand, if you like, there's nothing in that point, it's absolutely hopeless, or
Exactly.
it's unmeritorious, or whatever other phrase one might have used. Query whether at that point one would have expected the judge to have said any more really than what he'd already said, which was, I don't accept that Cathay Pacific is on all fours.
I mean, he'd just be repeating himself.
Well, except I think Mr. Milner's point is, no, wait a minute, there's a difference between a judge that says, I don't agree, I don't accept your argument, and the test for permission to appeal, which is whether there's a realistic prospect of the judge being wrong.
I agree, but...
Because if you're right, I suspect your junior doesn't need to stand up and say anything
Well,
on the next point
no, well,
that he's teed up to argue.
I'm not sure he does need to say anything, but that's a matter for you. But your lordship, the problem with all of this is context is so important, and if you had let's say a lengthy, I mean, take the substantive issue where Mr. Justice Robin Knowles has delivered a couple of 100 pages worth of judgment, and they had 10 different arguments that they said were worthy of going to the Court of Appeal, or however many it was, I can't remember. So you would expect him to address those arguments because they're arguments that arise at the leave to appeal stage. In relation to this currency point, Mr. Milner had nothing further to say beyond my point is an arguable one, and I should be allowed to run it in the Court of Appeal. What the judge is saying is, I don't agree. It is sufficiently arguable for it to trouble the Court of Appeal. And I would respectfully say he didn't have to say anything more than that. If he'd expressly said those words, I would suggest the point wouldn't arise, that he wouldn't have to give any more reasoning than that in relation to this type of point. And I would, you're judges, I'm not. I would suggest that in relation to this sort of thing, one can end up imposing quite a burden on somebody in Mr. Justice Robin Knowles' position who's dealing with this menu of things, to say that when nobody asks him to deal with things more fully than he did when everybody understood, I would suggest, what it was he was communicating. So, my lords, on the jurisdiction...
I think, speaking for myself, I'm more attracted by the other point, which is that if they wanted more, they should have asked for it.
Yeah, I mean, I think that is absolutely...
And that's,
I mean,
that's the reality. And again, that's a trait you see in quite a few of the cases. That I mean, the question is obviously is raised. Did you ask for more? And the answer is, if you did ask for more and didn't get any more from the judge didn't give any more. Well, that's pretty obviously an unfair situation. But if you don't ever ask for it, then the Court of Appeal might be inclined to say, well,
you can't complain. No, and that's the thing. You can't complain and say the judge was wholly deficient when you asked him permission. He says, "I'm not going to grant it." You say, "Thanks very much," or whatever the words were that Mr. Milner used. Yeah. Lord Hoffmann says, "Thank you very much," and no one says anything. And all you had to say is, "We're going to the Court of Appeal. We'd like a little bit more."
More reasons.
Yeah. So, my lord, unless there's anything else you'd like from me, I'm going to hand over to Mr. Ford. Thank you very much.
Thank you. Yes, Mr. Ford.
My lords, it's very important to note from the outset that P&ID, both below and now, has failed to identify any previous authority in which a foreign party awarded its cost of proceedings by the English court, which we term the receiving party, having been billed and paid its costs of those proceedings in sterling, has then been debarred by the paying party from straightforwardly recovering those costs in sterling. So that's what we're focused here, a situation in which very conventionally a foreign party has been billed and incurred the costs in sterling, and the other party seeking to deprive it of recovering in sterling. And that's unprecedented in terms of all the authorities out there. Nor is there anything unforeseeable in the outcome in this particular case. Nigeria, in response to a Section 66 application, as you've heard, was put to the expense of bringing a Section 68 application to vindicate its position for the English court, represented by English solicitors and English counsel. It was entirely foreseeable to everyone concerned that Nigeria would be billed in sterling and pay those bills in sterling and would seek and ought to be able to recover by reference to the sterling liabilities it has incurred and actually paid or is paying in sterling. Indeed, P&ID in fact was ordered to pay...
Sorry, wait. It was entirely foreseeable to everybody that Nigeria would be billed in sterling and would pay the bills in sterling. That's one proposition. Yes, I understand that submission. To say it was entirely foreseeable that Nigeria would seek to and ought to be able to recover by reference to the sterling liabilities that it has incurred and paid is actually the question we're here to hear argument on.
Well, one can say it's foreseeable in the sense that there are a number of interlocutory cost orders in these proceedings where Nigeria covered its costs in sterling. So those are in the supplemental bundle, my lord, at tab 2, tab 3, tab 4. And in all those instances along the course of these proceedings, it involved orders from the English court, including a consent order dated the 5th of May, which you find at tab 4, page 11, where it all involved P&ID paying Nigeria its costs in sterling in these proceedings. Now, in terms of navigating the course as to our submissions, which I'll then develop as briefly as possible given the time, Nigeria make 3 principal submissions. First, the judge's decision with respect was entirely appropriate and proper application of the long-established cost indemnity principle. Second, the Cathay Pacific and Lufthansa case, which is the linchpin of P&ID's argument, simply does not stand for the proposition that where a receiving party has incurred and paid costs in sterling, it should be debarred from recovering in sterling. Quite the reverse when the actual facts in that case are considered, which involved a euro incurred liability being entitled to recover in euros. And that was what the court actually had in mind in that particular case. He wasn't saying anything about a situation in which a party had incurred costs and paid costs in sterling being debarred from recovering in sterling. Insofar as the decision of the Deputy High Court judge in that case sought to equate cost orders with the principles applicable to damages, we say, first of all, that's obiter, second, it's wrong, and C, what principles the Deputy High Court judge actually sought to draw from those damages cases is entirely unclear. What you find nowhere in that judgment is any suggestion that a foreign party that had incurred and paid costs in sterling should not simply be able to recover those costs in sterling. And I think part of the error here is when you take a step back and look at the Folius decision, what that case was actually about was a situation in which the court, having accepted it had jurisdiction to make a damage award in a foreign currency, then considered the question of what currency the plaintiff should be entitled to recover in. And the first question, therefore, was it recovering in terms of its direct expenditure loss, or was it, actually in the case of contract, effectively applying the second limb of Hadley-Baxendale and able to go behind the currency of expenditure and recover in the termed in that case plaintiff's currency, i.e. the currency in which it might normally transact. So you're looking beyond the currency of expenditure. But the entire premise of the Folius is it was a position for the plaintiff to elect which of those routes it would go for, and it was for the plaintiff to prove if it was going for something other than the currency of expenditure. So there's no suggestion on the face of the Folius decision that that would debar a party from claiming the direct expenditure if it sought to do so. And what you've got is you've got the vague references in Cathay Pacific to, well, we can apply the Folius decision. We say that's wrong, but in any event, it's just entirely unspecified what it said you derive from the Folius in terms of that principle in that case. And third, we say P&ID's approach would invite unwelcome satellite litigation in almost all cases involving successful foreign listed parties. And as you'll have noted in our skeleton, the latest commercial court statistics indicate about 65 to 75%, I think, of cases in the commercial court involve one or more foreign parties. Now, in terms of the cost indemnity principle, we say the focus of the cost indemnity principle is squarely on indemnifying the liability a receiving party has incurred in relation to costs. And if we can, to save time, look at paragraph 18.2 of Nigeria's skeleton, which is at page 68 of the bundle. What you see is there's a whole number of cases, and these are absolutely, not the whole body of cases, but the focus is on the liability, and the court does not go behind the existence of such liability to consider the existence or otherwise of loss on some other basis, and that's a very well-established principle. So, provided the liability exists, costs can be recovered. And if I can turn up one authority very briefly, that's the HMRC and Gardiner authority of 2018, which is at tab 20 in the bundle, and at page 246.
Right, hang on.
Page 246, tab 20, paragraph 30, beginning, the authorities establish the following relevant principles applicable to the making of a cost order in favour of the successful party in circumstances in which another body or individual has undertaken to meet those costs. The indemnity principle will not be infringed if, and the one we rely on in particular is paragraph 5, if the receiving party establishes a contractual liability to pay the costs at issue, it matters not that it is highly or vanishingly unlikely that the receiving party will in fact be called upon to pay those costs. It is the liability to pay, rather than who makes payment, which is material. And consistent with that...
Well, that's the point about funders, isn't it? The fact that the cost may be being, that the party, the receiving party may be backed by a litigation funder, doesn't mean that you can't recover.
Exactly, but it goes further than that, and just to particularly identify two of the other cases at paragraph 18.2. The Bernstein and Times newspaper case, that was a case where the receiving party was impecunious, but was still entitled to recover pursuant to the indemnity principle, the costs for which it was liable. And the Sir Henry Royce Memorial Foundation and Hardy case, and that was one where the receiving party's discharge of its cost liability had been met by non-refundable donations from third parties. And again, it was entitled. So one looks to the existence and amount of the liability and does not go behind that to consider some other measure of loss.
Okay, can I just ask you for a second? You may know the answer to this, but are the relevant parts of those judgments that you just referred us to sidelined in the photocopies? Because you haven't put the relevant paragraphs in
Yes,
the
they are, my lord.
skeleton. So that's where we'll find them.
Yes, my lord.
Right.
And in terms of so what I was saying is one looks at the existence and amount of the liability and does not go behind that to consider some other measure of loss. So one does not say, for example, that there is overcompensation because the likelihood of the impecunious litigant having actually discharged its cost liability had it not won was very small. Likewise, one does not say, absent the litigation, the non-refundable donations towards the cost would not have been made, such that there is now overcompensation. None of that matters. One looks to the liability. And we say that really should be the end of the appeal. But moreover, my lords, there's an important fallacy running through my learned friend's submissions. Namely, there is a lot of rhetorical flourish that Nigeria is seeking to recover a windfall or is seeking to recover more than it actually expended to pay its legal costs or will profit. But in reality, there's no such thing, my lords. First of all, and fundamentally, Nigeria is simply seeking to recover by reference to its actual sterling cost liability. Nigeria is not seeking to recover any more than its actual liability in sterling. So the idea that it's recovering a windfall is wrong. It's got a sterling liability, which it will pay in sterling, and that's what it's seeking to recover. Second, and building on that, it's been said a number of times that Nigeria has spent Naira, but that's wrong. Nigeria has in fact spent sterling and continues to expend sterling to pay its legal costs. And again, it's not seeking to recover more than it has or will actually expend in sterling to pay its legal costs. The liability that there has been, has been and is being discharged in sterling. Put another way, had Nigeria not had to pay costs using such sterling sums, it could itself have retained the sterling amounts and benefited from the appreciation of sterling against the naira itself. What's happened here is that the expenditure has been in sterling. There's no windfall in that sense. But the third point is the simple fact on attacking this idea that there's a windfall. The simple fact is that even if naira was exchanged to acquire sterling over the course of the proceedings to pay the costs, the real value of that naira equated at the time to the sterling amounts now sought to be recovered. And that's a very important point. Because what is so striking about my learned friend's submissions is that there's a clear body of case law that establishes that had Nigeria in fact been billed and paid its costs in naira, as opposed to in sterling, it would be entitled nonetheless to recover in sterling at the applicable naira to sterling exchange rates that applied as of the date of such payments. So when you take that principle, what that takes you to is here, you don't have to look at what the exchange rate for the naira would have been at any particular time. You've actually just got the fact that Nigeria has always been liable and paid its actual costs in sterling. So of course, the naira amounts, any naira amounts converted, equated at the relevant time to the sterling amounts paid. And to make that submission good, it's worth looking into two cases briefly. First of all, the Deutsche Bank and Sebastian Holdings case, which you find at tab 24 of the authorities bundle, and paragraph 61 of that case. And that's page 330 of the authorities bundle, tab 24, 330.
Yeah.
The claimant, Deutsche Bank, had been successful in that action and was recovering its costs. And the issue arose that some of the disbursements incurred directly by the claimant were paid in United States dollars. And what had happened is that those sums had been claimed in 2019 in the cost schedule at the sterling equivalent on the date that the bill was finalised, so in 2019. And whereas the defendant contended, you read that in the third line, apologies, Mr. Vitt contends that the appropriate exchange rate should be that when the dollar payment was made. So here's a situation in which disbursements incurred in dollars, seeking at 61 to recover in sterling, and the question was, do you exchange at the date the bill was finalised or at the date the dollar payment was made? And then at paragraph 64, which is important, in the alternative, Deutsche Bank offered to claim the sums concerned in United States dollars. So they're saying either let us have the sum in sterling converted as of now, or we'll have it in dollars. And at paragraph 66 and 67, the court rejected that. And it says, it seems to me that the just solution is that the sums paid by the claimant in United States dollars should be claimed at their sterling equivalent at the time of payment, rather than at any later date. And at paragraph 67, there's also a practical advantage to the practice of the cost judge as described by Warren J, in that it's more straightforward to assess sums in sterling, even in the somewhat archaeological assessment of sums incurred 7 years ago, than another currency the fortunes of which may have fluctuated.
Yeah.
And consistent with that, and the other case I need to show you is the Macula and Romania case, which is at tab 32 in the bundle, which is my second authorities bundle. And paragraph 122 of that case, which is page 639 of the bundle.
Six three nine.
639, and beginning paragraph 122. The second issue we need to address arises from the way in which the second to fifth receiving parties have drawn up their bill. So the second to fifth receiving parties were entitled to the payment of costs by Romania and have drawn up their bill, in particular as to the methodology employed in converting costs paid in other currencies into sterling. So there's no suggestion in that case that the second to fifth receiving parties were not entitled to recover in sterling. What had happened at paragraph 123 is that White and Case, who had acted for the second to fifth receiving parties, had charged them in euros. The hourly rates claimed in their Supreme Court bill appear consistent with that to result from conversion from another currency. The bill, however, offers no information about the currency in which the second to fifth receiving parties paid their costs, or any process of conversion into sterling. And the 2 points to note is, first of all, there's no suggestion that despite having been billed in euros, they were not entitled to recover in sterling. And the issue between the parties was whether the conversion into sterling should be as of the date when the costs were paid, as Romania averred, or as of the date the bill was filed at the court for assessment. And if you go to paragraph 137, my lords, the court said costs incurred in a cited the Deutsche Bank case, costs incurred in a foreign currency should be claimed in their sterling equivalent at the date of payment, rather than at a later date, such as when the bill was finalised or the date of assessment. So taking our situation here, if you reverse engineer back to the Naira amounts and say, well, what was the sterling equivalent at the time they were paid? Well, you get to the sterling amount we are claiming in total. If you can then go to paragraph 142, which is page 643, there's brief mention of the Cathay Pacific case, and just a simple summary. With regards to currency, the principal issue he had to consider was whether the receiving party, who had been invoiced by its solicitors in euros, could have its cost assessment ordered in euros. He concluded that it could. The Cathay Pacific case is here not seen as standing for any wider proposition about debarring a party who had incurred costs in sterling being able to recover in sterling. It's purely about the question of whether or not a situation in which a party has incurred costs in euros might be entitled to actually recover in euros as opposed to in sterling. And if we can go to paragraphs 144 and 145, and I would ask your lordships to read paragraph 144 and 145. And then finally, paragraph 150 on 645.
Yeah.
And how does that apply here? Well, we say it shows the absurdity of P&ID's position. Because had Nigeria in fact been liable to pay in Naira and paid its cost in Naira, when it came to assessment, it would have been entitled nonetheless to claim in sterling by reference to foreign exchange rates as at the time it made those payments, which gets you to exactly the situation that in fact Nigeria is seeking to do, which is to claim the actual sterling amounts it was liable for and has paid. So there's no mismatch between those two propositions. And just to make that good, if you can look at table 19 of my learned friend skeleton, which is core bundle tab 5, page 57.
Just before we leave, Nicola, there is a reference to McInnes and Gross, Mr. Justice Coulson, as he then was. You didn't take us specifically, I think, paragraph 140, but it is referred to. Do you have any observations on that?
I will take you to that court's case separately, and it's relevant in two ways.
That's fine. That's fine. In
Certainly.
course of events.
So I'm taking you to my learned friend skeleton, which is tab 5, page 57. And what you'll see here is that column B is taken from Nigeria's schedule of costs provided at the consequentials hearing. So the figure of 42 million sterling represents the best estimate at the time of the consequentials of what the costs that had been incurred were. What's then happened is that at column D, you've had a reverse engineering, column C and D, where on the assumption at column C of immediate payment in each period at column B, they've looked at the average exchange rate. That at column D then has said what they have reverse engineered to be the costs incurred by Nigeria to settle invoices. Now, of course, and I think the point that the court made earlier, is that assumes that Nigeria never had its own sterling amount set aside or converted more at a particular moment in time, such that a period that there would be sterling on hand already. But what they've done is they've reverse engineered based on the average sterling to naira conversion rate as you see at C for any particular time. And then what they've done at at column E is looking at today's exchange rate, which you see at line 18, so the 1905 figure. They said, well, what exchange rate in sterling would what amount of sterling at column E would we now have to pay you to, at today's rates, obtain for you the naira amounts at column D? That's, first of all, totally artificial. But the actual answer here, consistent with the cases I've just shown you, is that the analysis the court would actually do is, had column D been accurate, and had it represent a situation in which Nigeria had in fact expended the sums in column D, what actually Nigeria would be entitled to on assessment are the figures at column B, because those represent the sums as of the exchange rates at the particular time that would have been recoverable. And what we're actually seeking to do is nothing of the sort. We're simply saying, at column B, those represent the actual incurred liabilities. Those are the amounts which Nigeria is liable to pay and has been paying, will continue to pay in sterling. And that's the figure we should be entitled to recover, consistent with the indemnity principle.
Well, and you might have discharged that liability, that sterling liability, to the solicitors. The mechanics by which you did it
Is wholly
are
irrelevant.
neither here nor there. I mean, you might have had sterling accounts.
Exactly, my lord.
You might have had dollar accounts you turned into sterling. You might have had naira accounts which you turned into sterling.
And of course, the point we make in the skeleton is the
You
fact
might
that
have borrowed the money in order to pay.
Exactly,
It's
my lord.
any number of.
And the point we make is that the fact that Nigeria primarily transacts in naira doesn't mean it never holds sterling amounts. Of course it does.
No.
Now,
Well, it would be highly surprising if it were paid oil revenues in anything other than US dollars, for example. So I'm sure as a sophisticated sovereign nation, it has a sophisticated treasury function.
Yeah. You know that, and makes the payments in whatever way is most favourable to itself.
now, second of all, that was really my point on, first of all, the fact that what Nigeria is seeking to do and what the court orders is entirely consistent with the indemnity principle. But also it's really wrong to see this through any prism of there having been a windfall or a profit being made. That's simply wrong. The second point, though, the headline point to address, is that P&ID's reliance on the Cathay Pacific decision is misplaced. And what we say is that, first of all, the context of that case is terribly important. As P&ID acknowledges at paragraph 20 of its skeleton, Cathay Pacific was a case in which a receiving party had incurred and paid its costs in euros, and was held to be entitled to its cost award in euros on summary assessment. And my learned friend said, well, the distinction doesn't really matter, but it was key to the reasoning of the court. And you see that at paragraphs 28 to 29 of that decision, and that's tab 22, page 280.
Tab 22.
And I would ask the court to read paragraphs 28 to 29 on page 280.
Okay.
And the reason I say context is so important there is if you look at the reasoning the judge was applying, what he was thinking he was, the premise of the decision in this case, is that where a party has domiciled outside the jurisdiction, has incurred substantial costs in a foreign currency, you see at 28, it's consistent with the overriding objective that he should be entitled by reference to that foreign currency. And it said, first of all, at the end of paragraph 28a, it's appropriate that he's recovering directly in the currency in which the costs were in fact incurred. But of course here, the costs were incurred in sterling. It's not a situation in which the costs were incurred in naira, they were incurred in sterling. Second of all, he says at B, it would be expeditious because making a cost order directly in the currency in which they have been incurred avoids the need for any currency conversion calculation to be carried out by the court or approved by the court. Because of course, the way my learned friend is trying to deploy this authority gets you into very complicated questions of currency conversions, because you're not being entitled to simply recover by reference to your sterling liability you in fact incurred and paid, but you're having to reverse engineer, trace back to work out when and what currency conversions occurred, and then only then are you entitled to somehow recover by reference to those naira sums. And that's not at all the exercise which the deputy judge had in mind at all when he was trying to create any proposition in this case. And then the next point to make in this case is at paragraph 31, the court considered the decision in Schlumberger.
Schlumberger, I think it is.
Schlumberger.
I'm very grateful. In Schlumberger, Schlumberger had been invoiced in euros, and the court sought a direct and the claimant had sought a direction that costs could be assessed in euros, and that was refused. And the judgment of the deputy judge cites from that case, you see at paragraph 28 and 29 at the top of page 282. And at paragraph 34, and I would ask you to read paragraph 34.
Yeah.
Now, what's important there is the deputy judge was not saying that Schlumberger was wrongly decided, but rather the case at hand was different, because the current case involved Lufthansa being accounted to in euros, including hourly rates in euros. So it shows that Cathay Pacific is all about the fact that the invoices and hourly rates have been in euros. Schlumberger was much closer to our fact pattern, yet there was no suggestion by Mr. Justice Kimball, by the deputy judge, that it was wrongly decided in awarding the cost there in sterling. So, what then happens in this case is that after finding that in principle the court had jurisdiction to order in foreign currency, you then have the later sections, which we say are obiter, suggesting that the principles applicable to damages ought to apply to costs. And we do say that that is wrong. So, if you can look at paragraph 47, which is page 284, we say the important point in the Brawley case is that the reference to the liability he has incurred, and that got overlooked by the deputy judge in his approach in this case. The fact that the indemnity principle is concerned with the liability that has been incurred. And then at paragraph 48, you get a leap in logic, where it said you can apply the folius, but not said what in particular is to be taken from it or how far this goes. And of course, the context in Cathay Pacific itself was simply that the costs had been incurred and paid in euros. And at paragraph 50 and 51 at page 285, again, you get no developed suggestion as to what that actually meant. It's using the language of currency which most truly expresses a loss, but it's not suggested the Schlumberger case was wrongly decided where the costs had been ordered in sterling, given the fees had been calculated in sterling, despite having then been translated and paid in euros. So it's really unclear what Deputy Judge Kimball had in mind in seeking to import from the damages cases and how far that was meant to go. And at paragraph 55, what it seems to be clear is that at 285 is that the judge had in mind a situation in which a party seeking to recover its costs was the one electing to recover in a currency other than sterling, not a situation here, like here, where what's actually happening is that, contrary to the normal rule that, first of all, costs incurred in sterling can be recovered in sterling, but also that if you've incurred costs in a foreign currency, you would be entitled to recover of sterling, that actually a party can seek to bar a receiving party from recovering in sterling. And the premise at 55 is very clear. It's about the idea that the party receiving its costs being entitled to seek to rely on another currency if it so wished to do so. And then finally, you get paragraph 58C at page 286. And where it said the court must determine which currency most truly reflects the claimant's loss, and therefore the currency in which it's most appropriate to compensate the receiving party for the cost which it has incurred. Now, insofar as one was trying to read that as simply saying, where costs have been incurred and billed in a particular currency, you might be entitled to recover in that currency, one might be able to live with that statement. But anything beyond that, we would say, is wrong. And paragraph 58C itself seems internally confused, because it says you have to look at the currency which most truly reflects the claimant's loss, and then the final sentence says that principle is also consistent with the indemnity principle which underlies awards of costs in England. And there's an inconsistency there, at least in the way that my learned friend approaches the reliance that he says you can place on the Cathay Pacific case. And insofar as Cathay Pacific is saying something other than you of course can recover in sterling when you've incurred in sterling, we say then, well, what it is doing is not consistent with the indemnity principle, contrary to what the deputy judge felt he was doing, as evidenced by paragraph 58C, final sentence. Now,
well, the short point is that the deputy judge wasn't dealing with the present situation at all.
entirely.
And whether he was right or wrong in what he said, he wasn't dealing with this situation at all.
Entirely
As you
correct.
say, he seems to have got slightly confused between claims for damages on the one hand and the issue of a liability to pay costs on the other.
Precisely, my lord. And we really say that the context of that case is very important in terms of not then running away with what it said to establish. And actually it's clear it's on very precise and particular facts. Now,
Well, it's one of the points, I think it's the senior cost judge makes the point, doesn't he? That it's, that, you know, it actually, it's a slight case of the sledgehammer to crack a nut, frankly, because it was a €25,000 bill on summary assessment, and we have a judgment that is, you know, 13 pages long. And the senior cost judge makes the point in that case, in the Deutsche Bank case, that was, I think it was that case, there's a liability there for whatever it was, 2 million.
and we do say it's wrong to equate costs and the principles applicable to damages, and that takes us to the McKinney and Gross case.
Yes.
A decision of the High Court. You find that tab 17.
17.
This is the decision of Mr. Justice Coulson, as he then was. And paragraph 17 is where the court should first of all go, which is page 212. The first defendant had been successful and awarded costs against the claimant. The first defendant sought an order that he was entitled to recover any additional sums that might be assessed to reflect any currency loss caused by the decline in pound against the euro since any payment of costs had been made. And that was refused in this case. And at paragraph 17, that frames the issue. You then get at paragraph 18 the reference to the Elker-Met decision, where you had you see at the end an uplift of £20,000 had been given. And then at paragraph 20, the court declined to follow Elkamet, and at paragraph 20 you said you read, and I'd ask your lords to read paragraph 20, and I'm also uncomfortable with the idea that an award of costs should be treated as an order for compensation as if it were a claim for damages. I consider there are inherent differences between the two regimes.
Yeah.
And at paragraph 22, you get the I respectfully decline to make the order sought in respect of currency conversions.
Yeah.
So first of all, that's a case doubting and not following the idea that you can equate costs simply with damages. And second of all, and as set out in our skeleton at paragraph 29.3, which you don't need to turn up at this point, but if one simply equates a costs order with the damages regime, well then why does it end with the question of currency? And it goes back to my learned leader's point that once you start saying within the rubric of costs you can recover losses, well then why can't you then recover other consequential losses in terms of other investments, or how you would, or quite, not even in terms of how you would have paid those costs, i.e. you've had to sell your company, you've had to sell an asset to pay those costs. That asset could have been valuable, but it goes further than that, because you could say, well, and more simply, had I not paid those costs, there was this terribly lucrative investment opportunity I was minded to invest in, but I didn't do so because I had to pay these costs. As a result, the true measure of loss in relation to costs liability, put aside the issue of currency, is this hugely inflated claim, because that's the business opportunity I lost as a result of having to pay costs in these proceedings. And that's why we don't equate costs with the damages regime, but that's exactly the type of issue that would be opened up if you adopt my learned friend's approach. Because why in principle should you stop at currency? The moment you stop at currency and then debar a party in my client's position from recovering in the currency in which it's incurred costs, why are you then not allowing it to look for other ways in which it suffered losses as a result of having to pay those costs? And that's an important principle against the what your lordships are being asked to do here. And we then go to the further point, which I introduced briefly, which is, it's very unclear what the deputy judge actually tries to draw from the Folias decision and the Dione case. But what we do say is that those are cases where it's all about the claimant in tort or contract having been able to recover, if it so chose, to try to prove a case, in a case to bring a claim other than for its direct expenditure. So what you're really looking at in those cases, in the contract sphere, is the application of the second limb of Hadley and Baxendale, and that's what that case is about. It's not saying that the claimant in those cases would have been debarred from recovering had it made direct expenditure and recovering in that direct expenditure. And I can make that good very quickly, my lords. If you can go to tab 2, page 22, which is the Folias.
Yeah.
No, that's a wrong reference, apologies. It's tab 2, page 20. Tab 2, page 22.
Yeah. Page 22.
Page 22. And if I can ask you to read from F over leaf to B.
Yeah.
Down to letter B, did you say?
Around letter B, and then
Right where it ends about reasonably foreseeable, isn't it?
yes, and then pick up again at midway between G and H in this case, on the page, G and H. So, but even in that field and still more outside it, cases may arise in which a plaintiff will not be able to show that in the normal course of events he would be expected to use the currency or one of the several currencies in which he normally conducts his operations. The burden being on him to show this, and consequently the conclusions will be that the loss is felt in the currency in which it immediately arose.
Yeah.
And finally, Lord Wilberforce at page 28 of this decision and beginning with a rule, so 3 lines down, and ending at was borne by the plaintiff, my lords.
Yeah.
Now, it's in the Texaco Melbourne case, which is at tab 5 of the bundle. It's very important in that case that what had happened in that case was that cargo owners had sought damages in dollars, and that was refused. But the fact pattern was that the cargo owners had not in fact expended dollars on a replacement cargo, and it was being rejected by the court that the loss could be deemed in dollars in that situation. And I simply take you in that case to tab 5, page 49. And at the bottom paragraph, the first sentence I'd ask your lords to read. Of course, the situation might have been different if the department had in fact bought in fuel oil on the available markets to replace a cargo which was not delivered, and had done so by itself furnishing the US dollars required to pay the price. So what we would say is that even looking at the damages cases cited in the Cathay Pacific decision, nothing in those cases, and I believe those cases were the Folius and the Dione, nothing in those cases lend itself to, or was intended to establish a principle that a foreign party to English proceedings that had incurred and paid costs in sterling would be prevented from recovering in that direct expenditure if it wished to do so. Now, the third and final point is that matters of public policy strongly support the reasoning and approach of the judge in this case. And in the interest of time, I would just take you through paragraph 31 of Nigeria's skeleton, which is page 76 of the bundle.
Yeah.
Now, the first point to note is that, and this is at paragraph 31, second sentence, P&ID itself acknowledges at paragraph 28(2) of its skeleton that an award of costs in a different currency to the foreign litigant's home currency will inevitably impose a penalty on one party and confer a windfall on the other, at any rate where the exchange rate has substantially changed since the costs were paid. So, the unwelcome repercussions of P&ID's approach would be that in all English proceedings involving a successful foreign litigant seeking to recover costs, henceforth the parties would be encouraged to investigate and seek to go behind the straightforward position of the currency in which the costs were incurred, to look for some other measure of loss. And 4 points are worth very briefly highlighting. First of all, at 31.1, you've got the statistics as to quite how many cases in the commercial court involve foreign litigants. But then second of all, at paragraph 31.2, you've got the complexities that this approach adds. So you've got two complexities. First of all, you've got the having to establish, on my learned friend's case, that what you do in this case is you have the actual sterling liabilities that were incurred, which you can find from the bills of costs and in the cost schedule. You have to then reverse engineer to work out how many naira that took at the time to acquire, and then when you're repaying Nigeria its naira amount, you pay that by reference to today's exchange rate. But in order to do that, you've then got to trace back historically as to what rates applied, establishing when in each and every payment by Nigeria of its sterling cost liabilities occurred, taking into account any amount of sterling that Nigeria held at the time and was using or ready to discharge. So all of that would be a cumbersome and costly process. But moreover, and I think this picks up a point that your lordships made in some of the questioning earlier, and this is page 78, P&ID's position makes no sense in that it fails to address how in its case the costs are actually to be subject to detailed assessment as has been ordered by the court. So are you doing detailed assessment by reference to the reverse engineered Naira amounts at today's exchange rate, in which case the whole of Nigeria's costs are an absolute bargain at some 12 million in total compared to the 29 or so million incurred by P&ID in these proceedings? Or are you assessing in the first instance in the sterling amount and then only then reverse engineering back to Naira? How is it said to work? And we say that actually it creates huge uncertainty and huge satellite litigation. At 31.3 we make the point that such additional uncertainty in satellite litigation is inconsistent with the overriding objective and the idea that costs should be, even if significant, something that can be dealt with by the court relatively cost effectively in a way that does not take up a huge amount of additional time and complication, and that this approach would invariably, in a huge number of cases, both summary assessment and at the end of different trials, add hugely to that process. And then at 31.4 we make the point that if you are saying that the currency, you have to investigate what currency truly reflects the receiving party's loss, such that a foreign currency is awarded despite the costs having been incurred and paid in sterling, there's no principled reason why such investigation should stop at currency. And that would then bring in the consequential loss points I've been mentioning. Now, we don't say that should happen, because we say, of course, you don't equate damages to costs. But if you do that, well, then you should be entitled to bring in and pray and aid other consequential losses you have suffered. So that was a slightly whistle-stop tour through our submissions in the interest of time, my lords. But unless I can assist you any further, those are our submissions.
No, thank you very much.
I think I preserved some 10 or 12 minutes or so, and I know your lordships will keep me to that.
That's fine, as long as the staff are happy to stay. I think they are. I'm not seeing anybody concerned. You're all right, are you? Jolly good. All right, thank you very much, Mr. Chairman.
I'm grateful to everybody. Starting with the currency point, while it's fresh in our minds, insofar as anything is fresh at this time. Our case is very simply that the court should apply the principle articulated in Cathay Pacific that costs are awarded in the currency which most truly reflects the loss suffered.
Yeah.
Now, the respondent rejects that, but what is the alternative approach? It seems to be that costs should automatically be ordered in the currency in which they were invoiced. That is the liability that the client incurred. And so it follows, if one takes that strict approach, that costs should always and invariably be ordered in whatever currency the client has agreed to pay his solicitor. Now, the implications of that are quite startling. First, it's not what happens at the moment. So your lordships are being asked to lay down a new principle, even on the respondent's approach. It's very common for solicitors to bill clients in one currency and then seek costs in sterling, whether it's dollars or euros or something else. Secondly, it means that the currency of the award is entirely dependent on the private arrangement that the receiving party happens to have agreed with his solicitor. And that may lead to arbitrary results. It may lead to a cost award that has really nothing to do with the litigation or the subject matter of the litigation or even the parties to the litigation. If a party has decided for his own commercial reasons to be invoiced in Swiss francs or whatever it may be, and then
it leads automatically to a costs order in Swiss francs. It's a somewhat bizarre outcome in a case where neither the parties nor the dispute has anything to do with Swiss francs. There must be more flexibility in the cost jurisdiction than that. And of course, the biggest problem with it is that it results in very unfair results in circumstances where there's been a big currency movement, whether it's a windfall, as in this case, or a shortfall, and that there is then no way to address that. Certainly there would be no way to address it in the case of a windfall. In the case of a shortfall, there may or may not be, depending on whether there's a power to order a top-up payment. But in my submission, the proposition that costs must always be ordered in the currency of the bill to the client is not what happens, and it would lead to significant problems of its own, including very often arbitrary results. Now, going on to some specific points that my learned friend Mr. Ford made. First, it was said that costs are a liability, an indemnity against a liability, and your lordships were taken to some cases on that, including the Gardner case. That was a case where the court said in terms that the indemnity principle is not infringed where, among other things, the costs are paid by a third party. But it's one thing to say that costs can be ordered because the indemnity principle is not infringed. As I said, first of all, none of those cases have anything to do with currency. It's a different situation. But even if the principle applies in relation to currency, it's irrelevant whether or not an order in sterling would breach the indemnity principle. It doesn't answer the question whether the court should go on to award costs in a currency which truly reflects the actual loss. Then it was said that there's no windfall in this case because the costs were paid in sterling. Well, with respect, the answer to that is obvious, that assumes that sterling is the currency which most truly reflects the loss, but the whole point of this argument is to determine whether there is a principle in which, whereby one looks to the currency of the loss, and if one does, and the currency of the loss is naira, as it plainly is, because naira is the currency of Nigeria and the currency which it used to buy the sterling to pay the costs, then there is plainly a windfall. And the facts are really indistinguishable in that regard from the Folias, the Texaco Melbourne, and the other cases where this has been considered. Just in terms of what the facts are, it's in the supplemental bundle at page 18. One sees, this is a letter from Nigeria's solicitors. At the bottom of page 18, going on to page 19, they say in terms that as the Federal Republic of Nigeria, it is self-evident that our client primarily transacts in naira, and indeed, sorry, this is at the bottom of 8 and going on to 9, and indeed has regularly exchanged naira for sterling on the foreign exchange market to discharge costs liabilities. So it's not, although it was suggested that Nigeria might have sterling lying around that it chose to use for its own reasons, that isn't the case. And indeed, there were more submissions about this at the consequentials hearing. The relevant passage in our skeleton is page 44, paragraph 25 of the supplemental bundle, where we said it's to be inferred that any costs were paid from a naira fund and will be paid back into a naira fund, and there's never been any attempt to take issue with that. Then, my lord, you were taken to the cases of Deutsche Bank and Mikula, and a slightly bizarre submission was made that the whole currency issue makes no difference because they would then end up getting naira converted as at the date of payment, in which case it becomes completely circular. That isn't right, because in both of those cases, there was no dispute that the costs order was to be made in sterling and that was the appropriate currency. So by contrast, if your lordship decided that Naira was the appropriate currency for the costs order in this case, then plainly there'd be no question of converting the sums into Naira as at the date they were paid. That would be pointless. The whole point is to ensure that a windfall isn't obtained as a result of the appreciation in sterling between the date of payment and now. In those cases, starting with Deutsche Bank, the facts were that some of the costs had been paid in dollars, and the issue was as to the date of conversion, bearing in mind they're going to be paid in sterling. And the judge said that the just solution was that the conversion should be done at the time when they were paid. But this wasn't a case where a loss had truly been suffered in dollars. As he said, it was an international bank that could have paid in any currency it liked. It was a matter of chance, essentially, what currency the costs were paid in. And there was no reason to give the claimant a windfall in sterling terms because it had chosen to pay in dollars. None of that assists with anything that your lordships have to decide in this case. And if anything, it can be said to support our position because on the basis that sterling was the appropriate currency for the order, it was the amount of sterling that was spent at the time that was relevant and not the higher amount of sterling that would need to be paid as at the date of the bill, and which would have led to a relative windfall. And similarly in Mikula, it's common ground that the order should be made in sterling. The court followed Deutsche Bank and ordered the conversion to take place at the date of payment, and the effect of that was that the party who had chosen to pay costs in euros, they were international businessmen in that case, bore the risk of the currency fluctuation instead of the paying party. And so there was no windfall gain as a result of the depreciation of sterling against the euro. None of that is anyway determinative or even really relevant for these purposes, except insofar as we see the court fashioning a just solution to avoid penalising one party and giving a windfall to the other. Now, my learned friend said that if there is a principle of election, it's for the receiving party to elect and not the paying party. That, with respect, can't be right. It can't be heads I win, tails you lose, so you have to pay in whichever is the more valuable of the currencies. If the receiving party is entitled to apply for an order in a foreign currency, it must equally be open to the paying party to make the same submission the other way around. And I think finally on the currency, the McInnes case, which is at tab 17 of the authority, that is a case, as we know, on whether there's a jurisdiction to order a top-up payment by way of costs. Now, and the judge decided not, disagreeing with the decision in Elkamet. Now, that provides no support for the argument that costs should be ordered in the currency of the invoices. That simply wasn't the issue, and plainly the judge wasn't intending to say anything about that at all. All he was saying was that a costs order is not supposed to provide full compensation for all of a party's loss, and so there is no reason why the costs jurisdiction should extend to awarding an additional payment over and above the actual amount of costs to ensure the claimant is fully compensated. And that may be correct, but it's not relevant, even indirectly, to the issue on this appeal. As I said earlier, if the receiving party truly experienced a loss in euros, then the obvious and elegant solution is to order costs in euros, and then this whole thorny question about additional compensation doesn't arise. But for completeness, while the conclusion may be correct, the reasoning is not quite correct or not expressed as precisely as it could be, perhaps, in this sense that an order for costs plainly is compensatory. The reason why you don't recover 100% of your costs is not that the order isn't compensatory, it is simply that you are only compensated for your reasonable and proportionate costs. But to the extent that the costs are reasonable and proportionate, a cost order is intended to compensate you for that expense. It is, of course, a separate question whether there's an additional power to award a top-up payment for losses over and above the amount of the costs themselves. And while I'm on that point, in response to the argument that this would open the floodgates to arguments about remoteness and alternative transactions and so on, that simply doesn't follow with respect. The head of loss, so to speak, for which the costs order compensates you is the legal fees that you are liable to pay. That's what you get compensation for. Anything else, in terms of what other uses you might have made of the money or anything like that, is irrelevant. And the only question is, in what currency should you be compensated for that loss? And in my submission, there is no reason not to apply the same approach to that as to awards of damages, for all the reasons developed in the Folias and endorsed in Cathay Pacific in the context of costs. That was all I was going to say, and I know I'm out of time on currency. So far as jurisdiction is concerned, I don't think I need to say more than very brief things about that. 2 points, very, very brief if I may. First of all, on section 68(4), your lordships have been pressed with the policy of avoiding delay and expense. I respectfully endorse or associate myself with the suggestions Lord Justice Snowden made to my own friend, that one can't take that necessarily too far. Obviously, any refusal of permission to appeal would save cost and expense, but the statute is not as far-reaching as that. And in that connection, can I refer your lordships to the judgment in Sumakam, which is where my learned friend started.
Yeah.
It's page 175 of the authorities. This was a decision on section 69, and the question was whether the parties had excluded the jurisdiction of the court. In that context, and specifically whether that issue was caught by the Bar on Appeals, and in that context, at paragraph 30, having held that that decision was not caught, Lord Justice Waller said, the following factors have persuaded us that the Court of Appeal does have jurisdiction. First, although there might be a temptation in the interest of speed and saving expense to construe any part of the language of the 1996 Act in a way that renders all decisions under the various sections where permission of the court is required as final, there's a distinction between cases where the court is overseeing the arbitration process and cases where the question is whether the jurisdiction of the court has been excluded. Now, of course, we're not dealing with a jurisdiction point in this case, but I do urge your lordships to have regard to that, insofar as it shows that one can't simply take a broad brush impressionistic approach and say, well, because it would save expense, therefore there shouldn't be an appeal. One has to look quite carefully at what exactly, as a matter of construction, is excluded and is not excluded. And we submit that for the reasons I developed earlier, the costs orders such as those in this case are not included. We say there's no material difference, therefore, as between this case and the Manchester City type case. So far as case management orders are concerned, which may be said to sit on the spectrum between the two, a lot of the discussion and my learned friend's submissions proceeded on the assumption that cost management decisions are all called. I don't want to go over that ground again. This case isn't about a cost management order. There is no case which holds that a case management decision is called, and your lordships may prefer to leave that question open, but in any event.
Well, you said there's a distinction to be drawn between case management before the event, where it's easier to say it's part of the process, and a cost judgment after the event, which you say is after the process has come to an end.
Potentially, yes. I mean, as I said, that isn't the only distinction I draw, but
yeah, you have two streams. One
exactly.
is what's the juridical basis for the order, and then the second is it part of the process leading to determination of the section 67-68 challenge?
Yes, I mean, I've got three strands really. I've got, first, the juridical basis. Secondly, is it within the substantive compass of Section 68 challenges, in the sense that it could lead to the overturning of an award or the decision on award, and that's the distinction I draw between the DIAG and NIOC type case, where the decisions were part of the machinery of the challenge, as it were. But then the third point is the temporal point, that it comes at the end of the process and not on the way to the decision. My Lord, unless I can assist further, that's all I intend to say.
Thank you very much, Mr. Lord. Well, thank you all very much indeed for your extremely helpful submissions. Inevitably, we'll reserve judgment. We will provide you with a draft of the judgment in due course for any typographical errors and the like, not for inviting the court to revisit issues. Please pay attention to the terms of the embargo at the top of the draft judgment. So, thank you very much indeed.
Authorised able.
Thank you for sitting.
Thank you.